Hello, everybody. This is Ondine Snowden. I'm the chairperson of the meeting. It's 3 o'clock now, and although there may be other people who are logging in at various points, I suggest to start. In terms of, can everybody hear me?
Yeah.
Yep.
What I'd like to do is save questions for the end, just for the benefit of the recording, and also we do have a lot of material I'd like to go through. Before I start, though, I know there was some confusion when I did an in-person presentation before, and some people had been expecting a somewhat different topic. I'm hopeful that everybody was aware that what we're talking about is policing in the criminal justice system. Yes.
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 Yes. Yes.
Yes.
So we have a chat function. I'm not sure if it's available or for everybody. But what you can do if you want to ask a question and you're afraid you're going to forget it, is put it in the chat window, and I'll try and get to it at the end. I suspect I wouldn't be very adept at multitasking and trying to type in my answer as I give this presentation. So, although I might, never know. But I'll try and leave about 15 minutes at the end. I think we're scheduled to be here for about an hour and a half. I've done this seminar before. It's taken me approximately an hour and 15 minutes to go through the slides, or an hour and 10 minutes, which should leave us some time at the end. So what I propose to do is mute everybody so that there isn't a lot of background noise interfering with what I'm going to say. And as I said, if you have a question and want to post it to chat, I'll try and get to it at the end, as well as unmute us so we can all hear each other. My name, as I said, is Ondine Snowden. I'm a lawyer, and I practice largely in Abbotsford and Chilliwack. And my area of practice is principally defense. So a person that likely the bane of your existence as you take victims through the process of charges and trial, and I'm certainly ready to answer any questions that you might have about my role as well, if I don't touch upon what you want to know about what I do during my presentation. So comments and criticisms and suggestions are all very welcome as well. I am going to start what is essentially a brief overview of the criminal justice system, from investigation to sentencing, with a concentration on how it affects people charged with and as victims of domestic violence. Okay, it's a little slow here. In terms of the language I'm using, any of you who have taken...
the conference has been muted.
Any of you who've taken a woman through the process of charges and potentially through trial will know that the term victim is rarely used. That's because in the criminal justice system, and this is very basic, the accused person is presumed innocent until they're proven guilty at trial. The accused has charter rights to a fair trial and to that presumption. The Crown is not the lawyer for the victim, and this can present some problems and some misunderstandings, but it's important to go on in understanding that although you know the person that you're assisting to be a victim of violence, they're the complainant as far as the criminal justice system is occurred, and the offense or the crime that's being committed is an alleged offense. A victim's rights are considered to a certain extent in the criminal justice system, and I will go into what rights a victim of crime has in the system. But it's sometimes very difficult for a victim of a crime to understand why all of the benefits that seem to accrue to the accused. But those rights are there for all of us, and it's part of the system. So I'm going to go through this, and Having given that preamble about language, I'm accustomed to referring to complainants or to victims as complainants, to accused persons who are actually victimizers as accused persons, and to alleged offenses rather than offenses. But for the purposes of this presentation, I'm acting on the assumption that we're dealing with victims of violence for the most part, and I'm not going to mince words, and I will refer to victims of violence as just that. Finding that the transition from slide to slide is rather slow. I had to make some very general remarks about investigative techniques. As everybody here knows, local police forces, or RCMP in Canada, conduct most investigations, and most are initiated by a call from either a complainant or another member of the public through 911 or calls to non-emergency lines. There are also special police initiatives such as task forces, and in some jurisdictions there are special police initiatives to do with domestic violence, but most of those calls are still initiated by calls to 911. With respect to investigation of domestic violence, 911 calls in British Columbia that involve domestic violence are supposed to be designated as a priority for assessment and response, and so that if the police receive a number of different calls, they should be responding promptly and first to domestic violence calls. The investigation is supposed to focus on risk to the victim, and I'll explain the ways in which that is supposed to occur. Many people are under the assumption that police have to refer charges to Crown Counsel in every case, but it's rather a strong recommendation wherever there is evidence that an offense has occurred. So even where you have a victim who's reluctant or uninjured, for example, the police are still strongly encouraged to refer that offense to Crown Counsel. So when you have any evidence, for example, injury, or a third party who says that they've seen an offense of domestic violence occur, the police should be referring that offense to Crown. Many of you will have encountered a situation where both parties are alleging that the other person is the aggressor. And a lot of men and other abusers of both genders will preemptively call the police when they realize that they've committed an act of violence to try and get themselves out of trouble, and police will arrive, and there'll be two parties there who are saying that they were the victim of the assault. Police are strongly encouraged not to arrest both parties. What they are encouraged to do, and what they're directed to do, in fact, is engage in what's called the primary aggressor analysis. They're supposed to look at the situation, interviews with witnesses and the parties or party that called 911, and look around at the scene of where the offense is alleged to have occurred and determine who has the superior strength, ability, and means for the assault. Determine the history of the relationship, including previous charges. So they should be looking in their databases and seeing if there have been other calls to 911, for example. They have to determine who suffered the worst injuries and whether there are defensive wounds that would demonstrate that one party had simply been defending themselves rather than attacking the other party. This is something that they should do whenever both parties are alleging that there's been an assault. You often hear people complaining later, well, I don't understand why she wasn't arrested because she actually hurt me, and police are supposed to engage in this analysis. I can't say that every time they do or that they get it right, but this is what they're instructed to do. With respect to interviewing witnesses and suspects, police are trained to separate witnesses, and this is particularly important in situations where there's a vulnerable victim. They're also encouraged to record interviews wherever possible, because sometimes women will be happy to give an interview when, I shouldn't say happy, but willing to give an interview when something's first happened. But the next day, for example, they start getting concerned about separating from their partner and how they're going to manage or whatever it is, or maybe they're being threatened. And so they might be reluctant to go back and give a formal interview to police. So police who are responding to these types of calls are expected to bring recording devices where they can. They should also provide interpreters, and I can't say that they always do. They try and make an attempt to do so. In Abbotsford, I've spoken with the person who heads the domestic violence response team with the Abbotsford Police Department, and I was impressed by the fact that they make an effort to really freeze the scene and take a great deal of time at the scene, which is something I hadn't realized before. That's the correct response for police. And as I said, it may be ideal and it may not be taking place, but that is what is encouraged. Of course, the accused has to be provided with access to a lawyer if a lawyer is requested. The police will often search and seize exhibits, for example, weapons, where weapons are alleged to have been used. There are other investigative techniques that rarely come to play here. Photographing injuries is an important one in these types of situations. And what I encourage those of you who support victims of violence to do is not only ensure that the police take photographs when something first occurs, but also arrange to go back and have photographs taken later, because things like bruises, for example, may appear as simply a red mark on a woman's face. Days later, she'll have a large bruise on her face. If the police aren't being cooperative in doing this, and I'll talk about this later, it's important to record and preserve that evidence in as much as is possible. There's also, of course, forensic testing, which everybody's familiar with, which may or may not come to bear here. It's often most important in stranger assaults and sex assaults, but it can play a part in certain situations. There were a number of questions raised at the live seminar, and also I think provided in advance by some of the participants about special types of evidence and how they can best be presented to a court. One of the things that comes up often in domestic violence situations is that there are harassing, threatening communications through media, such as emails. In discussing how best to present email evidence in court, the police prefer that the entire message is saved in a woman's inbox so that the police can search through and go through the interface. And forgive me for my lack of technical expertise here, but apparently if they go to header on the actual inbox, they can see the IP address and other tombstone information that will help them connect that email to the particular computer in the particular residence through subscriber information. Women are to be discouraged from forwarding emails to the police because the data is obscured then. Also, a print up from the little print function on an email is not necessarily helpful. If there's some reason that the police can't be shown that email in an inbox, a screenshot with the header information is helpful. In terms of text messages, what police often like to do and what's ideal is that the cell phone might have to be given up temporarily so that police can do a data dump and a forensic analysis of the information there so that they can present it in the fullest way possible to the court, which can present particular problems for vulnerable women who may not have any other means of communication. And so as a person supporting those women, it's something that everyone should turn their mind to, that this woman, in order to preserve the sorts of evidence she needs, may need to give up her cell phone temporarily, and some accommodation may be needed if there is any way to assist her with a temporary cell phone, for example. Facebook is being used more and more commonly, and as it becomes more widely used, it's also being more widely used by perpetrators of domestic violence. Threats and harassment occur on Facebook, and Facebook presents a particular difficulties for a court because Facebook is a non-Canadian company. It's an American company. And in order to be able to explain how records are created in Facebook and what goes on behind what we see on the screen, an expert from the States would have to come up and be prepared to testify in court in order to make that the sort of evidence that would be accepted by a court. For example, it came from this particular IP address, this computer at this residence for this subscriber. All that is obscured and not available to the court. Unfortunately, Facebook is not prepared, or hasn't been prepared to send witnesses to court in Canada for domestic violence harassment files. It's only with sexual offenses and offenses involving children that they've been prepared to send someone up to testify here. So that doesn't mean that Facebook messages aren't of any use. What it means is that the court needs to be able to decide that there's sufficient circumstantial guarantees that a Facebook message comes from the person that the witness believes it comes from. For example, I know it was my husband because in this chat or in this message he mentioned our anniversary and what we did together, and nobody else knows that. And so I'm certain it was him, and these are the indicators. So in a situation where a message is clearly from the party who it seems to be ascribed to, a witness may be able to convince the court on the criminal standard of beyond a reasonable doubt that it does come from that person, but only through descriptions of its content. Phone calls themselves present another issue because, of course, they come when we're not expecting them quite often. What the police suggest and what I'd suggest is if phone calls come on a landline and the number is a familiar one, if you can put the phone call on a loudspeaker and record it, that kind of evidence could be used in court. Or if another person is around, if they overhear it, they could record what they've heard and be able to testify in court that they recognize the person's voice, for example, and this is what was said. At the very least, always keep a written record of every phone call that's made. Even if it's a hang-up call, a written record is going to be of assistance in court in making evidence seem reliable and trustworthy. The heading here says special types of injuries. I think what I intended to say was special types of evidence, injuries being the evidence that I was going to discuss. I mentioned this briefly before. If the police don't take photographs, they haven't done their job very well. And in most cases, they will take photographs if there's a visible injury. However, if they don't take photographs or if they don't take follow-up photographs particularly, an uninvolved person, for example, a transition house worker or a support worker or other person who isn't a witness to the actual offense, could take photographs and keep notes of when those photographs were taken. The person should be encouraged to go to a doctor and make sure the doctor keeps a record. For example, tell the doctor how the injury was incurred and make sure the doctor is making a note of that. And later try and get those records for the police because it becomes difficult if the police have to get some kind of an order. Even if a woman doesn't intend to report what has occurred to police, women should be encouraged to always keep these sorts of records because things may escalate and she may change her mind at some point, and to have a record of something that occurred 6 months before can allow Crown Counsel to approve charges where they might not otherwise be able to if the record of it wasn't accurate and complete. A peace officer or police officer can arrest a person without a warrant when they're found committing an offense, or if the peace officer believes on reasonable grounds that they have committed or are about to commit a serious offense. Once a person is arrested, they may be released on what's called a promise to appear, which simply has a court date when they're to appear for their first appearance. The police officer, and in most cases involving a victim and violence, may impose conditions on a document called an undertaking before they release someone. If they have the legal grounds to do so, police officers may also hold a person in custody until they can be brought before a justice or a judge for a bail hearing. This is very common with domestic assault. The victim's safety is something that may need to be investigated further, and they may want the additional security of having that person released by a judge if they're to be released at all. In British Columbia, all criminal charges must be approved by Crown Counsel, which means that once police arrest someone, that doesn't mean they're charged, not until the Crown has seen and considered the police information and approved charges, and a justice or judge has sworn that what's called the information, which is the charging document, will charges be officially approved in this province. What happens is police gather all their information, recordings of interviews, and a report typically that they prepare for Crown Counsel, pictures of injuries, etc., and they submit what they can in a timely manner to Crown Counsel, who then considers that the information that's gathered and they apply what's called the charge approval standard, which is a two-pronged test. I see that someone has a hand raised, and perhaps I'll unmute this so that if there's a question that I can answer.
The conference has been muted.
I will.
The conference has been muted.
Was there a question?
The conference has been muted.
Oops.
The conference has been unmuted.
Hi, was there a question?
Yeah, it's Elaine. I was wondering, are these handouts going to be available to us?
They are. They are. Actually, Darcy Bennett from Pivot actually has these, and I think she'll send them out to all the participants.
That's great. Thank you very much.
Thank you.
Okay, I'm going to mute you all again and continue. And
this is fantastic information.
Oh, good. I'm glad.
The conference has been muted.
The charge approval standard is a two-pronged test. The first standard that charges have to meet is that there's a substantial likelihood of conviction, and this means that looking at all the information, can Crown Counsel make out the charge that they want to, and do they think they can get a conviction if they go to trial? The other part of the charge approval process, and both parts of the test have to be answered positively, is it in the public interest to proceed with the charge? So in some cases, for example, a woman's being the victim of domestic violence over a lengthy period of time, and on one occasion she decides to preemptively strike her partner for whatever reason. Crown Counsel might determine in that sort of a situation that it isn't in the public interest to proceed with that charge given the context. there are many other situations, I think, as plentiful as many as we can imagine. But that is the traditional test. In the domestic violence context, however, there's a somewhat, or the possibility of applying a somewhat different test. In the first place, it's considered to be generally in the public interest to proceed with prosecution where the victim is a vulnerable person, including a spouse. So these prosecutions almost always go forward if the other part of the test is met. However, in some cases of domestic violence, the Crown doesn't have to feel that there's a substantial likelihood of conviction. The threshold is lowered so that they can proceed even where there's only a reasonable prospect of conviction, which means where there's a victim who's showing some reluctance or has given contradictory statements, for example, the public interest is so high in bringing this prosecution forward that charges may be approved even though they don't feel like the likelihood of a conviction after trial is substantial. Victims of violence should contact Crown always if they haven't been contacted by Crown, and the earlier the better, because their input at a bail hearing and in the charge approval process is going to be invaluable. Crown counsel can't always imagine the particular risks that a woman who's the victim of violence might face, and so the earlier that contact is made, the better. After charges are approved or during the process of charge approval, Crown does what's called an election. Most offenses in the criminal code are what's called hybrid offenses, and Crown can proceed summarily or by indictment. What that essentially means is if they consider it to be less serious, they can proceed summarily. If they perceive it as more serious, they can proceed by indictment. That will affect things such as the mode of trial and also the length of sentence available. So if someone has a long history, for example, of domestic assault, and the 6-month maximum on a summary conviction, it seems too slight for what's occurred, they may proceed by indictment so that they can ask for a lengthier sentence. If the accused person was not arrested or was released on a promise to appear without conditions or with conditions that were inadequate, Crown counsel can seek a warrant for their arrest so that they can bring them before a judge to have a summons issued. So even if the partner of someone who's experienced domestic violence has been released, if a woman feels that the conditions that are binding that person aren't adequate or not protecting her, she can contact Crown counsel, and Crown counsel has the discretion to bring that person before the court. Alternative measures diversion is a way of taking an accused person outside of the traditional court processes and dealing with them in a more restorative fashion. Crown counsel can refer people to alternative measures, as can police. The criminal code says that measures have to be part of an authorized program. For instance, some of you may have heard of John Howard's John School or Mission Restorative Resolutions. I think there's one on the North Shore as well. This can happen either before or after Crown counsel has approved charges. The Crown or police determine whether it's appropriate. The person must accept responsibility, so this isn't a sort of situation where a person says, I didn't do it, and they get diverted. That won't occur. There has to be sufficient evidence to proceed with prosecution. So again, it's not a situation where we don't think we can successfully convict this person, therefore we'll send them through alternative measures. The advantage to the accused of participating is that if they do, they won't get a criminal record as a result, but also any statements that they make can't be used later if they don't successfully complete the alternative measures program. In British Columbia, well, actually, I'll go back. There's a special policy in BC with respect to domestic violence and whether alternative measures are appropriate. And the factors considered by Crown or the police are that there has to be no significant physical injury. There can't be any indication of a history of spousal violence. This has to be a first-time event. there can't be any evidence that there's a significant risk of further offenses which could result in serious harm. It can't be inconsistent with the protection of society, and there has to be, and this is the sticking point in British Columbia, an established domestic violence alternative measures program in place. And I know there's currently one that's sort of a pilot project in Vancouver. I'm not sure if Duncan has one. They have specialized domestic violence courts. There isn't one in Abbotsford or Chilliwack, for example, and I'm not certain about other jurisdictions, but this is something that is being piloted around BC, so it's not commonplace at this point. Now, I've spoken about bail hearings. They're also called show cause hearings or judicial interim release. Where it's necessary, an accused person is taken before a judge or justice if there are concerns about their safety or that they won't report to a judge. The police won't release them, but will rather take them before a judge or a justice. In Canada, and I'll say it again, there's a presumption against detention. Detention means keeping an accused person in custody pending trial or the resolution through a guilty plea. That means that most accused persons are released on bail. An accused person has to be released with or without conditions unless the Crown can show a legal reason, and I'll go into what those reasons might be, why they should be kept in custody. There are certain situations called reverse onus situations where the accused is given the responsibility of showing a reason why he or she should be released rather than the Crown having to show why they should be kept in custody. These, interestingly, include breaches of bail when a person's on bail for an assault, so they do become critical if somebody isn't complying with their bail. As I said, most accused persons are not kept in custody pending trial or sentencing, and so some people are horrified at victims of serious violence, are shocked that people are released. But this, along with the presumption of innocence, are critical tenets of our justice system, and they're there to protect all of us. Release with or without conditions is the norm. Sometimes, if the court feels it's necessary, the court will impose a cash or a surety bail. The Crown has to show a legal reason for conditions to be imposed or for cash or surety bail. The conditions can vary, but they must be reasonable. So anything that a judge thinks is a reasonable condition can be imposed. There aren't a limited number of conditions that can be imposed. It's really anything that they can think of. And so, again, the input of a victim of crime is very important at the bail hearing stage. The conditions will remain in place until trial or sentencing, until the matter is concluded before the courts, unless they're changed by the court. And I'll go into that some more. I spoke earlier about Crown having to show legal reasons for detention, and those reasons fall into three broad categories. The first is called the primary grounds, and it talks about where keeping the accused in jail is necessary to ensure attendance in court. So this ground for detention or keeping a person in custody has to do with whether or not that person is can be expected to attend for their appearances, for their trial, etc. Where an accused person has a record of not coming to court, for example, where there are bench warrants or charges in the past, convictions for failure to appear, or where the accused is deemed a flight risk, for example, they're from out of province or from another country, these may be grounds for detention. The court's first line of attack is to try and reduce that or negatize that concern by, say, seizing a passport or ensuring that a person reports and presents cash bail. But sometimes the risk is too high, and an accused will be detained because they have such a significant history and there's such a risk of them not coming to court for their appearances. The secondary ground is something that's of great significance in the context of domestic violence. A person can be kept in custody for the protection or safety of the public, and that includes any and all witnesses and victims of the offense. And they can be kept in custody where there's a substantial likelihood that they would commit a criminal offense or interfere with the administration of justice. Examples of this are where an accused person has a history of violence with the same or other people, a history of interfering or threatening witnesses, for example, a lengthy criminal record of any sort, or a record for not obeying court orders. And sometimes the secondary ground can come into play even when that person doesn't have a history of convictions, where, for example, there's a 911 call and there's evidence of the accused shouting in the background and uttering credible threats, and that person has the means to carry out those threats, access to weapons, for example, and evidence before the court that's real evidence, not just what somebody says, although that is evidence as well. But like I say, the example of the 911 call where the accused is heard saying, "I'll kill you and I'll kill your children, and I'm going to use this knife," or they're known to have access to knives. In a case like that, even if the person doesn't have a criminal record, they may be detained, although, again, it's unlikely. The conditions will simply be more stringent for release in most cases. It's also what's called the tertiary ground, or third ground, and this is rarely used and is often used in cases where there are firearms used, for example, or in cases of murder. But again, the caveat that even persons accused of murder, for example, regularly get bail in this country. So this is very, very rarely used as a grounds for seeking the detention of an accused person. In the domestic violence context, Crown is directed to do certain things with respect to bail. Again, I mentioned this before. They should seek a warrant if the accused poses a threat and the conditions of their release by police aren't adequate. Crown should seek a detention order, whether or not they get one in court, seek to detain the accused pending trial, where there's a substantial likelihood that the accused will cause severe bodily harm or death to another person. Crown should consult with the police and the victim to determine what sorts of conditions are required to keep the alleged victim safe. Now, that victim service workers and transition house workers may also have a role to play and may also be able to assist Crown in determining what sort of conditions to seek. Victims and their support persons should contact Crown as soon as possible to express their concerns. Common conditions, which many of you may have seen for domestic violence offenses, are reporting no contact. Sometimes there are exceptions, and that's another thing that is important for victims of violence to communicate to Crown. Area restrictions, no go to residences and schools and workplaces. Sometimes a residence condition that prescribes a certain place for that person to live, say at a recovery house. If alcohol or drugs are involved and that person has a plan to reside there, the judge may order that they do so while awaiting trial. Abstinence conditions from drugs and alcohol, where drugs and alcohol play a part in the offense. Weapons restrictions and other conditions such as curfew where they're appropriate. Again, the message is talk to Crown Counsel at the earliest possible opportunity. Breaches of bail are something that I'm sure you're all familiar with. What needs to be kept in mind is breaches are criminal offenses. When a person is on bail and they have a no-contact condition with another person, it's a criminal offense for them to contact that person. If an accused breaches when they're already on bail, as I said before, this may become a reverse onus situation where they have to prove to the court that they can be released. A victim of violence should always request a copy of the conditions that an accused person is on and request that Crown or police notify them if the conditions are changed. A victim of violence or a witness to violence should call 911 every time the accused contacts them in a way that they're not allowed to. So familiarize yourself with the conditions. Most times, accused persons can't text, they can't wave, they can't make, aggressive eye contact with a person. 911 should be called every time. A record ought to be kept. Persons who are on those conditions need to get the message early on that those conditions are in place for a reason. If the police won't act, if they consider it too minor or dismissive, Crown Counsel should be contacted. They're instructed in this province to take all of these concerns very seriously, and there's always a chain of command. If the first police officer doesn't listen, there's always somebody in a superior position to him, and the same goes for Crown Counsel. Now, this is a situation that I'm sure you're also all familiar with. What if the victim wants contact? In many cases, the victim of violence will need to have contact for various reasons, and there is a way to go about it that helps to ensure that victim's safety. Victims of violence should be strongly advised to not contact an accused person who's not allowed to contact them, not only for the benefit of the accused person who can be breached, but also for their own safety, because the conditions, they need to feel safe to call police, even if they've been wanting contact. And a lot of victims of violence will be reluctant because they've encouraged that contact, and another offense occurs, and they'll feel that they might get in trouble. That contact shouldn't happen. If a victim of violence wants contact, they need to let Crown Counsel know immediately. Crown Counsel will sometimes be stubborn about it. They'll refuse to assist that person. That person, a victim of violence, can contact a lawyer of the accused person, who can also potentially be in a position to assist with making that contact occur. Variations or changes of conditions have to be made by a judge in court. So if a victim of violence is contacted by her former partner or her partner, the person who committed the assault, for example, and they say, oh, I'm allowed to contact you, chances are they're not. Chances are the victim would have been contacted if that matter had gone before a judge. And a victim of violence can find out whether that's true or not. But they shouldn't believe that something like that is true just because they're being told it's true. Crown Counsel's permission is needed to apply to very conditions in provincial court, but not in Supreme, and that's why I say that the lawyer of the accused might be able to assist if Crown Counsel isn't being cooperative in assisting. Most persons aren't held pending trial, but those that are usually held in provincial pretrial detention centers. And the court can impose conditions of no contact even when a person is in pretrial custody or serving a sentence, so Crown should be asked about that. There's a piece of legislation in BC called the Victims of Crime Act. Victims of crime have the right to certain information, and I say victims of crime because from the perspective of this piece of legislation, even alleged victims of crime do have the right to information. They can find out about the status of the police investigation, the charges, why Crown Counsel decided to charge certain offenses and not others, the date and location and reasons for important court appearances and the outcome of those appearances. If Crown Counsel isn't assisting, a person can contact Victim Link BC. The numbers there are the Victim Safety Unit, and a formal application can be made if they're not getting the assistance they require from either police or from Crown. The victim also has a right to know the length of the sentence, information about how to report breaches, contact information for agencies who make decisions about release and conditions of release. They have a right to know parole dates for those who are serving a federal sentence, and how to make representations at a parole hearing. They have a right to copies of orders setting out conditions for the accused or for the offender that are relevant to their safety. Victims sometimes have the right to know where their right to know doesn't outweigh the offender's privacy rights, some of the following information. where the offender is serving a sentence, when a release will occur, how long that person will be on supervised release, and what those conditions are for parole or probation, if there are changes to the conditions of supervision and what they are, and if the offender is being supervised, whether that person might be in their area. Under the Victims of Crime Act, victims of crime may also have a right to a lawyer in certain situations, for example, where the accused asks for certain private information to be provided, for example, a diary or counseling records. Victims, if they meet the financial criteria of Legal Services Society, legal aid, can have a lawyer represent them and fight the accused's attempts to get certain kinds of information. They also have a right to provide their input on sentencing, which usually comes in the form of a victim impact statement. That statement can only include certain kinds of information. It can't include recommendations for sentence. For example, I think that person should go to jail for 2 years. It's supposed to be about what the victim has experienced and essentially what the impact of the offense has been. I have a timeline here for the process of the criminal process once a matter comes to court, from arrest to a bail hearing in most cases, to a first appearance, and I'll explain what each of these appearances are, to fixed date appearances, and there may be many of these before what's called the arraignment hearing, which is when a trial date is set and the parameters of that trial are discussed, to a trial confirmation hearing or a focus hearing. Sometimes there's a preliminary hearing or a preliminary inquiry, a guilty plea, which can occur at any time during this process, a trial if there's no guilty plea, and sentencing if there's a conviction or a guilty plea. A first appearance after a bail hearing or after release by a peace officer is the time when the accused receives a package of what's called the particulars, which are the documents that have been given to Crown by police that they've collected during their investigation. The accused can make further requests for material. They should also be told what Crown's initial sentencing position is, which is what Crown would seek from a judge in terms of sentence if the accused were to enter an early guilty plea. An arraignment hearing, as I've indicated, is the day when a trial date is set. In some courts in BC, the accused actually enters a plea of guilty or not guilty on that day. If there's a guilty plea, of course, the matter won't go to trial. The accused, in certain situations where the Crown has proceeded by indictment, as I indicated before, if they've proceeded with the charges, so it's more serious, the accused can determine the mode of trial, which includes whether or not they want to have a preliminary hearing before a trial in Supreme Court, or whether they want their trial to occur in provincial court, or whether they want a jury. The court assists in determining the length of trial, and if there's to be a preliminary inquiry, what the issues are and what the witnesses will be. There are also, as I said, fixed date appearances, and many of these may occur prior to arraignment. Disclosure discussions, that's what documents should be provided. Plea discussions and other preliminary matters are discussed. The arraignment I've discussed. There's a trial confirmation hearing in which the accused or the accused and his lawyer come before the court, and both Crown and accused have to indicate their readiness or their lack of readiness to proceed to trial. If the trial is to take place in Supreme Court, there's a pretrial conference, which has essentially the same function as a trial confirmation hearing. There may be bail variations and bail reviews. If a person is kept in custody, they may have another opportunity to show why they should be released on bail, or they may have conditions changed or deleted. A preliminary hearing is important because from a victim's perspective, it may mean that they have to testify on more than one occasion, both at the preliminary hearing and later at the trial. And the purpose of a preliminary hearing is like a screening process to determine that there's enough evidence to take the accused to trial. But that threshold is very low in Canada, so most cases will be committed to trial. At a preliminary hearing, it's very much like a trial in that the Crown calls its witnesses, some or all of them, depending upon what has been discussed with the accused. And then the accused or the lawyer for the accused has the opportunity to cross-examine those witnesses. Trial. Most of us know quite a bit about trials, but some of us have never been in a courtroom. The prosecution has to prove every part of every offense charged beyond a reasonable doubt. That's a very high standard, and it needs to be kept in mind by victims of crime. It's not easy for a Crown to prove its case. Witnesses, including complainants, victims, cannot be in the court until they testify. What happens first in a trial is after Crown makes some opening remarks often, the Crown calls its witnesses, including the victim, in whatever order they decide to do. And after the Crown goes through the evidence with the witness, and they're not allowed to ask what's called leading questions, they essentially ask who, what, when, why, where types of questions, the accused or his counsel cross-examine the witness. An accused person, once Crown Counsel has called all their witnesses, may or may not decide to either take the stand him or herself or call witnesses. Crown can cross-examine any defense witnesses after the witnesses for the accused give their evidence. After that, there's argument. The Charter of Rights and Freedoms is known to all of us. It may or may not be relevant in the types of proceedings that you're likely to witness and to be involved in. The accused has rights to be free from unreasonable search and seizure and false arrest. Some issues that may come up are Section 10 provides a right to counsel and access to counsel. If an accused makes a statement, even a full confession, if they haven't been provided with their right to counsel, for example, that confession may not form part of the evidence at trial and may not be considered. There's also something that comes up, which is unreasonable delay. When a trial takes too long to come before the courts and it's through no fault of the accused, the judge may decide to end those proceedings right there and the trial won't continue. So these are some of the ways in which the Charter may affect trials that you see in court. Testimonial accommodation is something that may occur in some of these cases. The Criminal Code allows for child witnesses to testify from outside the courtroom by video link or from behind a screen in almost every case where an application is made. Also, child witnesses have the right to have a support person present when they testify. In special circumstances, adult witnesses may be permitted to testify by video link or from behind a screen or have a support person there. But there are only exceptional circumstances where that will occur, and the judge has to be satisfied that the person won't be able to give a full and candid account if they can see or be seen by the accused, for example. That might require that the person bring medical evidence before the court that shows that they're going to have a panic attack if they see the accused, for example. It's not an easy threshold. It's not enough that they're simply afraid to testify. Again, it has to be demonstrated that they won't be able to provide a full and candid account if they don't have that testimonial accommodation made for them. In terms of how a judge considers the evidence of a witness, including a victim, they look at lots of factors. Some of the major areas that they look at are credibility. If a witness is given a statement either at a preliminary inquiry or to police, and at trial they give a statement which differs, adverse findings against their credibility might be found. Or if the accused is able to demonstrate that that witness has a motive to lie, for example, or the Crown in the case of Crown or defense witnesses. Reliability is also an issue, the reliability of the testimony. If the person makes many mistakes or their memory is not good of what occurred, or if they're not in a position to see or hear properly what occurred. For example, they're looking at something that's occurring down the road. They see a domestic assault happen, but it's dark and they can't recognize the persons. That can affect the judge's assessment of their credibility. And another factor that judges look at are whether the parties or the witness was intoxicated at the time the events occurred. And so this comes up frequently. If a person was drunk, the accused or his lawyer might attack that person's ability to remember or their ability to perceive things clearly at the time. The judge will also look at whether the story is consistent within itself or with the testimony of other witnesses, for example. The demeanor of a witness is also very important. If a witness is argumentative or combative with defense counsel, for example, the judge may hold that against the accused, and so witnesses should make eye contact with the judge, should refrain from getting in arguments when they're being cross-examined, and simply keep their composure if they're able, which is unfair in some cases because there certainly are occasions when they're being attacked, their credibility and their reliability are being attacked, but it's to their advantage, and their testimony will be received better if they're able to keep composed. Of course, the evidence the accused and his or her witnesses are subject to the same considerations. A decision at trial can be of different types. Again, the standard is proof beyond a reasonable doubt. Charges might result in a dismissal or acquittal. That's the same thing, or a finding of not guilty. They all mean the same thing. It should be emphasized that this does not mean that the victim was not believed. It may be that the judge believes that witness, but they simply haven't given evidence of all the elements of the offense. They can't remember certain things, for example, or their evidence is somewhat inconsistent with the evidence of other witnesses, and the judge simply isn't convinced beyond a reasonable doubt. It's a very high standard, and victims may feel that they were disbelieved, and sometimes judges don't let them know. Sometimes they do, but they should always be reassured that it doesn't mean the judge did not believe them. Something in the evidence left the judge with a reasonable doubt, or some element of the offense wasn't proven, or it may be a technical legal argument. A person may be convicted or found guilty. These mean the same things, or on some or all of the charges. There's also the ability for a trial judge to convict of a lesser included offense. For example, that person was charged with assault causing bodily harm, but the evidence of the bodily harm wasn't proven. For example, the bruises couldn't be seen in the photograph, or the doctor wasn't able to testify because the doctor didn't gather that evidence. So the accused would be found guilty of assault, but not assault causing bodily harm. That's one example. The judge also has the ability to impose what's called a common law peace bond, where they feel that in the interest of keeping peace and keeping people safe, even if there's not a conviction, they should impose some restrictions on the accused or a witness. Many people are familiar with stays of proceedings and peace bonds. In fact, they come up altogether too frequently in cases of domestic violence. A stay of proceedings is allowed through the criminal code. The Crown Counsel has a discretion to direct a stay of proceedings at any time after the commencement or after charges are approved. They can also withdraw charges or consent to the dismissal of charges. Peace bonds are probably familiar to you, and they're under Section 810 of the Criminal Code, and I'm going to talk about them a bit more. Crown Counsel will sometimes decide to resolve a domestic violence charge with a Criminal Code peace bond under Section 810 of the Criminal Code, a recognizance with conditions. They may do so in situations where a victim doesn't want to testify, but does have a fear of the accused. In those cases, the Crown may approach the accused or his or her lawyer and suggest there should be a peace bond. The advantage to the accused is there's certainty and there's no criminal conviction as a result. Crown Counsel may also not approve charges for an offensive assault, but rather proceed under Section 810 of the Criminal Code because they believe that person has a reasonable fear, in which case the matter would go along and go to a regular trial where what has to be demonstrated by Crown is that the victim has a reasonable fear. There are also civil restraining orders, and I'm not a civil lawyer, so my evidence, or my, my information may be a little bit lacking here. But some of the major differences between the two are that peace bonds can be sought against anybody from whom about whom the victim has a reasonable fear that they'll cause personal injury or damage to property. Restraining order, on the other hand, a civil order, there has to be a family connection. A peace bond is initiated by speaking with police who send a report to Crown where they feel it's justified. Restraining order is something that a victim has to apply for themselves in a court. Crown can seek conditions of bail with respect to a peace bond information, so there would be protection in place long before contested 810 hearing occurs, like a little trial. But with a restraining order, a victim might have to wait for the hearing of that application in order to get protective conditions unless they get an ex parte order if they're in immediate danger and can prove it to a court. For a peace bond, there's no fee because it's done in the public interest. With a restraining order, there's no fee if it's applied for in provincial court, but if proceedings, family law proceedings like custody or property division are already being dealt with in Supreme Court, there may be a fee for applying for a restraining order in Supreme. A peace bond lasts up to a year, and Crown can reapply if they feel there's still a continuing need for one. There's no time limit on a restraining order unless the judge imposes one on its application. The major difference from the perspective of police is that they feel that peace bonds are much easier to enforce. They can be enforced anywhere in Canada because they're pursuant to the criminal code. Restraining order, for example, may not be enforceable in a province other than that where it was issued. A breach of a peace bond is a criminal offense automatically if a package is sent to Crown, whereas if a person disobeys a restraining order, Crown Counsel will sometimes lay a charge, but I haven't seen it very often. The Protection Order Registry is a database that the BC government or the BC courts hold. All protection orders that are issued in BC, whether they're 810 peace bonds or restraining orders in civil courts, should be in this database. Police can call that database and do so if someone alleges a breach. However, it's not a fail-safe system, and so victims should always confirm that their order is registered by calling Victim Link once they have a copy of the order and ensuring that that order is registered so that when police call, they know precisely what sorts of conditions are in place and they're in a better position to enforce those conditions. This is a big question, I'm sure, for many of you. Does the witness have to testify? And the answer is a kind of mixed one. If a witness, a victim, receives a subpoena for court, a subpoena is a court order. A person who's subpoenaed does not go to court could conceivably be found guilty of contempt of court. They could be fined or they could be sentenced to a period of jail even. The Crown, if somebody doesn't show up on the day of trial, has the legal ability to apply for what's called a material witness warrant. If they can show the court that the person received a subpoena and that they're likely, and this is the sticking point, to give material evidence. So if you have a person who's repeatedly told Crown, I'm not going to testify, I'm not going to testify, Crown Counsel is going to be hard-pressed to be able to demonstrate to the court that that person is likely, if they're brought to court according to a warrant, that it's likely that they give material evidence. So it's not automatic that Crown would have the right to a witness warrant if someone doesn't show up. Perjury is giving a false statement under oath, and where a person is particularly vulnerable to this is where they've said one thing at a preliminary inquiry, for example, and then they're called later at trial and recant. But perjury is difficult to prove. There has to be evidence, circumstantial evidence to assist in the prosecution. It's not an easy charge to make. A witness could be jailed for up to 8 days if he or she does not cooperate, refuses to testify at a preliminary inquiry. All that being said, Crown Counsel does not want to re-victimize the victim, or at least they're directed not to re-victimize the victim. And so in most cases where the offense isn't deemed to be especially serious, if a witness doesn't want to testify, Crown Counsel is not going to force them to do so. You sometimes see them seeking material witness warrants in situations where they feel the victim is being intimidated into not testifying, for example, or where there's a serious history and a very serious risk to the complainant if the prosecution doesn't proceed. But in most cases of domestic violence, Crown Counsel is not going to try and force the witness to testify or threaten them with perjury or contempt of court. If a victim doesn't want to testify, they need to let Crown know immediately. Hold on, I'm going to unmute us for a second. There's a hand raised again. Oh no, it's gone down. I will answer all these questions at the very end. I have to sort of speed through. I think I'm almost finished. Crown will be concerned that any reluctance to testify may be the result of pressure or coercion from the accused. So if a victim doesn't want to testify because they're frightened or because they simply want to put this behind them, they need to put that in words for Crown Counsel to allay Crown Counsel's fears that it's about being pressured or coerced. Crown may agree to an alternate form of disposition like an 8-10-piece bond or alternative measures in some cases where a victim is unwilling to testify. Crown is not supposed to apply for a material witness without considering all the circumstances, of course, the legal test being the first and foremost, but they also have to go to the administrative or higher up Crown before doing so. So it's only in very rare circumstances that will occur if a witness doesn't show up. Stays of proceedings are frequently entered, unfortunately, in these types of situations. Crown Counsel has the discretion to drop the charges by staying proceedings at any point after charges are laid. If Crown doesn't feel the prosecution is in the public interest anymore, or if they feel they can't secure a conviction, they may enter a stay of proceedings. If a witness refuses to testify, Crown will often enter a stay of proceedings either before trial or sometimes on the day of trial where they have a reluctant witness or one who doesn't show up. Crown can restart the prosecution again within a year. They'll only do this, though, if they find out that the reason a victim didn't testify or didn't show up was because of pressure or if new evidence arises. It's unusual. Guilty plea can be entered at any point in the criminal process. It doesn't happen as often in domestic assault charges as with other charges because of the difficulties in prosecuting them. But most files are resolved by guilty plea. Negotiations often occur between accused and Crown may agree to a plea to one, if not all of the charges, or a lesser included offense, for example. There are many sorts of sentences that are available. Discharges are a frequent way for more minor charges to be resolved. The advantage to the accused is there will be no conviction at the end of it. They can be either absolute or conditional. So someone may be on what looks like a suspended sentence. If they abide by all the terms, at the end it's deemed not to be a conviction. Suspended sentences and probation are also common. Those have conditions as well, but are served in the community. There are fines. There are conditional sentence orders, which are sometimes referred to as house arrest. There are essentially jail sentences in the community, and then there are provincial and federal jail sentences. There are also other types of sentencing options for very serious offenses. A life sentence is automatic for murder, indeterminate sentences for dangerous offenders and long-term offenders. There's also a section of the code that came in a few years ago, Section 752, which deals with serious personal injury offenses, which means that some violence and sexual offenses, a person can't get a conditional sentence any longer for those. The judge has to consider the Criminal Code Section 718, which outlines the purposes and principles of sentencing, denouncing the offense, deterring the offender and other persons, separating the offender from society, rehabilitation, reparations to victims, and to promote a sense of responsibility in the community. These are all statutory considerations, things that the judge has to take into account. There are also other principles that the judge has to consider. Proportionality, similar offenses or similar sentences for similar offenders committing similar offenses in similar circumstances. If there are two crimes committed and a person is going to serve two sentences consecutively, the judge has to take that into account and perhaps impose a shorter sentence than if there were separate ones. And there's a presumption against jailing if a non-jail sentence could be appropriate. One thing that's of significance in this context is that the judge has to take into account aggravating factors. These are factors that may lead to longer or harsher sentences, and they're outlined in the criminal code. If an offense involves spousal abuse, that is considered an aggravating factor. If it involves the abuse of a child, that may lead to a longer or harsher sentence. And evidence that the offender abused a position of trust or authority may lead to a longer or harsher sentence. So these are factors that are particularly relevant and that the judge has to take into account on sentencing an accused person. Mitigating factors are factors that lessen the sentence imposed or make it less harsh are not outlined in the criminal code and are as plentiful as the individual circumstances of any person can be. A person committed the offense because they're addicted and they've since gone through treatment and dealt with that. The accused has taken some form of treatment or counseling to try and address the factors that they have. The person was abused themselves and other sorts of things, as many as you can think of. The judge should take those into account as well if the judge deems them to be mitigating. Aboriginal offenders are also supposed to be, their circumstances are supposed to be considered. All available sanctions other than imprisonment are especially important for Aboriginal offenders. Appeals can occur as a matter of right in some cases, and also may need permission from the court to occur in other situations. A person who's been convicted but who is going to appeal their sentence or their conviction may be granted bail pending that appeal. Now I'm going to unmute us, and I'm going to endeavor to answer the questions that appeared in the chat first, and then open it up to any other questions. I think we have about 15 minutes left.
The conference has been muted. Bye.